Okay.
Good morning, good afternoon, everyone.
This is still morning where you are, isn't it?
Yes.
So, all right, and I've sent a text to Ship. Ship is at home this week, you guys. He's out in Hawaii. So, I don't know if he'll be joining us on time. He may be a bit late. It's a bit early in Hawaii at the moment. But I sent him a text message to remind him. So, and King, he was he on with the thread with us this morning? King? Hey, King, can you hear me?
Yes, I can.
Yeah. Was he on the thread with us this morning, Ship?
No, I
Okay.
haven't heard from him.
Yeah, this morning. Okay. All right. Well, hopefully he'll be joining us. All right. So we're going to talk about this New York case. I have my computer up here in front of me. So I've got on live coverage. So if there were to be a verdict in the case while we're talking, that would be exciting. We will see. I don't expect a verdict this soon, but stranger things have happened. So I do have that up. So if something happens, I will let you guys know right away. And like I said, hopefully Ship will be joining us here soon. But we wanted to talk over some of the issues. We haven't talked very much about this case because there's just so much lawfare going on, as everyone knows. Um, and also, none of us are New York lawyers, and so that's a bit of a handicap trying to discuss it. Um, but at long last, I think we should turn to this. And the main thing I wanted to talk about was, everyone I know, including myself, has been following in the news, developments of the evidence and witnesses as it's gone along. But I thought we might discuss the closing arguments and a little bit of the law that the judge gave the jury this morning, and then talk about sort of, how does this stack up with what normally happens in other cases in places where we've practiced, um, and then also like what do we think is likely to happen. So we got a number of topics to cover, so let's get to it. So King, I think we're in agreement about what the biggest issue on appeal might be if there were to be a conviction. But setting that issue aside just for a second, because I think we need to spend a good amount of time on that. Oh, here's Ship. Hey, Ship. Good morning.
I would like to lodge a complaint with the management of this organization.
Now
Do you
you
have
know very
do you
well that complaints
do you
are
have
not
a do
allowed.
you have a customer? Do you have a customer service manager, please?
You'd like to speak to the manager, Ship? I didn't know you were Karen. My goodness. And you know very well that in the dictatorship that I run, the complaints are strictly forbidden.
Well, let me add this to the mix for this morning, and it is morning.
I know.
I
I
was
told them. I told them you're in Hawaii. Poor baby
I
had to
was
get up
I
early.
was I was awakened at 3:30 a.m. by a phone call
Ooh.
from the Honolulu Police Department.
Oh no.
My stolen Lexus has been recovered. Did I want to come
Oh.
get it at 3:30 in the morning?
You're 2000 and what you said is 2005. Lex.
2005. 195,000 miles.
They want to know if you want to come get it at
The,
3:30.
the last thing I wanted was for them to find it.
Well, you do live on an island, my friend. How hard could it be to to find it? Oh my. Okay, so the folks don't know, but Ship has had some difficulties with theft of some property at his home because he's been here in DC a lot and in California and so forth. So, but all right, Ship. Well, your complaint is duly lodged and duly discarded. So, on to New York court procedure. Now, let me ask you guys. I have never tried a case in New York. I worked as a young lawyer. I worked a couple of times on white collar investigations that were being done by the U.S. Attorney's Office in New York. But those cases did not go to trial. So I don't have any firsthand experience of trial work there. Do either of you?
I've never tried a case there. I've spent days or months uh, doing legal work in the form of deposition and pretrial issues, but
Okay.
never a trial.
Okay. And what about you, Ship? Have you ever been in court there?
I've only spent 2 days in New York City, one in 1986 and the other last year.
Okay. All right. So everyone be forewarned, we have a lot of legal experience amongst the three of us in total, but almost none of it in New York. So, and it is still astonishing to me how much the procedures differ by jurisdiction. So, where I have practiced, Maryland, DC, and Virginia, and a little bit in Tennessee, the in federal court. There's no way these arguments would have gone this long. Just none. Absolutely zero chance that you would have had 2 hours of summation by the defense and then 6 hours by the prosecutor in one day and go until 8 o'clock at night. That would not have happened in any of the courthouses where I've practiced. So, what do you guys think about that? Let's just start with sort of a simple issue here.
Well, the longest closing argument I ever gave as a prosecutor was 8 hours.
Wow.
All right. The case took 4 months.
Right.
There were 100 witnesses and 2,000 unique exhibits.
Right.
So, the judge gave me a full day. And then there were 4 defendants, and each of them took, I think, 3 hours. So we went 2.5 days. But, it's a long, drawn-out conspiracy over 2.5-year time period.
Multiple defendants. Right. Yeah,
Right.
exactly.
Yeah.
That makes sense. I asked Steve, folks who don't know, my husband was a federal prosecutor for 10 years and has been a defense lawyer now for 40. And I asked him this morning, he said the longest summation he ever gave was in a complex rape murder. And he thought that was 3 hours. So
Yeah.
he's tried over 100 trials. So the longest I've ever gone was 2 hours, and that was in a heavy document intensive case.
Yeah. My record is 3.5 to somewhere between 3.5 and 4 hours in a RICO / unfair trade practice case that took like 8 years to pretrial to get it to trial, and then worlds of documents and witnesses.
Multiple forests were killed in that case, right? Yeah.
I guess the only excuse you can make is, the prosecution was hampered by the fact that they couldn't choose among the 6 different predicate crimes that they didn't have to prove, but they needed to argue. I mean, I am stunned at what a clown show that New York process is. Whether it's a feature that happens in all courtrooms like that, notwithstanding law and order, or if it's just this judge who let this thing run so far off the rails.
Oh, I lost Ship. King, can you hear me?
Yes, and I can hear Ship too.
I can hear you, Leslie. Can you hear me?
All right. He's a speaker. Ship, I'm going to send you a co-host
All right.
invite. That seems like it solves the problems. I meant to do that, but then someone interrupted me very, very inartfully with this complaint about the customer service. So see if you can get us a co-host, and that may fix the audio problem.
Now it says I'm a co-host, although it doesn't show myself.
Okay. Ship, start talking.
King, can you hear me?
Yes.
Yeah, so he can hear me. Okay, now I'm a co-host.
All right. I still can't hear him. Good grief.
King,
I
tell
hate
her
it when
I'm
Spaces
going to
does
sign off and
this.
I'll come back again.
He's going to sign off and come back.
Yeah, and sign back on. Okay, good. That usually fixes it. So I am in agreement with what he was saying substantively, which is that it's absurd. It's really absurd. That's the only word for it. There's no need for the arguments to go on that long in a single defendant case that's not super complex, as this one is not. Ship, I'm sending you another co-host invite, so hopefully we don't have that problem
All right.
again. And it's just, to me, that's just a weakness in the prosecution, just on his face, that it took them 6 hours, because you've lost the jury. You can't argue 6 hours in this kind of a case and hold their attention. That's ridiculous.
Well,
Ship,
my
yeah,
earlier
go ahead.
comment was, but if you're hampered by the fact that there are 6 possible predicate crimes that you don't have to choose from. And
Right.
you know, what happened in that courtroom, it just befuddles me. That
Right.
if anybody thinks that's even representative in any fashion of trials that happen across
Right.
the United
Or due
States, it's just
process. It's clearly not.
yeah.
Yeah, I
You know,
agree. Let me ask you
Can
this.
I
Yep.
weigh in here? I yeah,
Yeah,
I
go ahead,
think
Gene.
this was the end of pretty much a off the rails process that began with the indictment.
Yeah.
Uh, the uh, the
So really, why should we be
yeah,
surprised that the arguments are any different?
because each the underlying or the basic crime that was charged is only a felony if it's done in furtherance or with the intent to commit another crime
Or
or
cover up
cover
one.
up one.
Right.
But the indictment and the prosecution, when asked, refused to land on what that other crime was. So
And the judge didn't
and did
make them
not
do
make them
that.
do that.
So,
And
right.
that defect then kind of drove the entire clown show, I'll call it, because you end up with jury instructions that have the same defect. The prosecution still was not required to marry a single crime that he's asking the jury to find is the predicate for the false uh, bookkeeping entries. And that being the case, you've got both sides kind of arguing in the abstract. What if it's this? What if it's
Right.
that?
Dancing
Yeah.
around. Right. Exactly. Yeah. All right. So let me make a couple more observations about the length of the arguments, and then we'll dive into that issue, King, because that's one of two really central legal questions in the case that probably actually will be of more interest if the former president is convicted, and of less interest if he gets acquitted or if there's a hung jury somewhere in between. So my observations about the length of the time is Leo. Uh, good grief, Leo Nye. Do you guys remember him? Nizer, actually, is was a famous trial lawyer, and there's a famous quote attributed to him. He said, "A speaker who does not strike oil in 10 minutes should stop boring." And this is sort of the way trial lawyers look at it. Like talking longer, if you're not addressing new subjects as you go along, is not advancing the ball. And I would think that would be particularly so with New Yorkers. I mean, wasn't it Johnny Carson that said the shortest period of time in the world is the time between when the light turns green and when the New Yorker behind you starts honking his horn? You guys think that a New York jury would be impressed with these long summations?
I don't think any person, it doesn't matter whether you're in New York or not. I mean, I've seen jurors' heads nod after 30 minutes. You know, and when
Yes.
and I thought it was kind of telling when Merchan said, so again, I'm only reading what's reported on Twitter as we go, and then some of the after action
Right.
reports. But when Merchan said, for the record, and never, people who are practitioners need to never forget the judges say these things for the record, so that later on
Right.
it's there in black and white if somebody questions it. Merchan said, like at 6:30, well, the jurors all appear attentive to me, so we're just going to continue on until we're done. It's like,
Right.
that's riotous. The jurors are attentive
Right.
after 7 hours. There is nothing, there is
Exactly.
nothing more stupefying and boring than to sit passively in a juror chair and listen to lawyers drone on about stuff that you have heard about now for 4 weeks.
Right. The only thing that's worse than that is then having to sit there and listen to the judge give you the instructions in the same
Yeah.
case. I mean, that's when I've seen most jurors literally fall asleep is during the instructions. So, but the other
you know,
thing is,
they're flashing exhibits up on the screen, and this is
yeah,
sort of this is the you know and I to me this is the thing that lawyers who haven't done this a lot don't recognize. You've lived with the case for how many months or years? All those
your
you've
years, right?
examined all those documents dozens of times. You could repeat a lot of them by heart. You start flashing them up on the screen to the jury. Say, remember this and this said that, and this said that. Remember so and so testified. It's like, what did that person testify to? You know, it's like,
Right,
what was the other document he was mentioning? That you know, they can't make
right.
those connections because they haven't lived with it for years.
Right, and they don't have everything in front of them. And this is something I've said for a long time. We probably need to overhaul is too strong a word, but we probably need to change the way we do trials for the modern time because trials, the way we do them in court, are based on the old-fashioned, hundreds of years old at this point model that people take in information through their ears and hold on to it and then can use it and evaluate it. And that's not the world we live in anymore. We live in a visual world, and all the testimony comes through, and the jurors are not given transcripts. This judge today isn't even giving them copies of their instructions to use, so they're supposed to sit there and listen to this guy tell them the law for an hour and remember it all and be able to apply it. And I just think that that is a farce.
Well, think about this. You know, we're all of the vintage that we can remember when you did a closing argument. You would have like maybe 10 or 12 of the 4x6 foam boards with portions of
Right,
documents blown up on the big foam board that you put up on the easel
right,
in front of the jury, and you
right,
call their attention to these specific things. Well, there was a certain amount of expense that went along with getting those made, and it sort of, except for rich civil clients like Kings, it sort of puts you in a position that you couldn't send the client a $38,000 bill for closing exhibits. Well, in
right,
the era of PowerPoint,
right,
it's got 85 slides in closing that just flash by the juror's eyes with little snippets of documents,
right,
and to go 7 hours, intermixing documents and witness testimony. And remember when this guy said that? It's absolutely ineffective, and it is counterproductive.
right. It is ineffective. It bores the crap out of them. And so they come away in the closing not having a strong, I don't think, understanding or outline of what the lawyer's arguments are. The other thing I personally don't like about this procedure is the judge giving the instructions at the end. I've always liked it better where the instructions come first and then you can refer to them in your argument. Now, if so, folks know, even if the judge doesn't instruct the jury first, the lawyers, when they start their arguments, they know what the instructions are going to be. That's all been worked out, and you've made your objections, and the judge has ruled on them, and you have a copy when you do your argument of what the instructions are. So you it's not like you're flying blind, but the jury is. They have no idea what the instructions are going to be. Um, and so, in the last few trials that I tried, I was able to persuade the judge to give the instructions first, and then you can use as one of your exhibits the instruction for whatever offense you're talking to them about, and show them how your argument fits into the law that the judge has already given them. So it's obviously New York procedure to do it the other way around, but I think it's less helpful to the jury. What do you guys think?
I agree 100%. But even in cases where the instructions follow the closing arguments, uh, you can. It's best to get permission from the judge to
Hmm.
use at least
A
an
visual,
outline of what he's
a
going to tell
visual.
the jury
Yeah.
the law is, and you use that outline to fit the facts that you think you've proven to.
Right. You have to do it
Right.
anyway. And then it depends on your judge how much he's going to let you
Yeah.
say, make reference to the instructions.
And most
Um,
judges let you do that.
yeah. So I don't understand why, as a profession, we haven't therefore changed, because it is the situation. Most places, the procedure by rule or by order of the court is that the arguments are supposed to come first, and the last thing the judge does is give the law. Now the theory of that is that, and this is true in theory, that some things could change as a result of the lawyer's arguments, and the instructions might be tinkered with at the last minute, but I've never seen that happen. Have either of you?
No, but I mean, I had many examples. I had many instances in trials where the judge split the closing instructions. He gave a certain number of them pre-instructed before the arguments, and then he had 10 or 12 that were at the end of the arguments, and then turned the case over to the jury.
Right. And this judge did that a little bit. He gave them some instructions, I thought, which judges often do at the beginning of, like, the rules, the instructions that relate to how to evaluate the arguments. Right. But then he didn't give them what the substantive law is going into it. So I, I just think it's more helpful to the jury to do the other way around. I know for double damn sure it's more helpful to them to send them back a copy of the instructions, because then they end up arguing about, without the instructions, they end up arguing about, well, what did the judge say the law was?
Right.
Especially if you have two camps, decided camps within the jury, then what happens is they can't resolve it because their notes are different or they remember it different, and then they send a note that says they want the instructions reread to them, about whatever, and then you got to sit through another reading of whatever the instructions are. It's moronic the way we expect jurors to be able to apply the law in these cases. It's absurd.
Yeah, I haven't had the experience that I can recall recently where the instructions did not go into the jury. Sometimes that can be problematic. They sit down and begin dissecting them, and they come up, but in my view, it's preferable that they have some guide than they have
Yes.
no guide.
Right. Right. Exactly. So right. So that's all stuff that's happening kind of in every case, and you see it in the microcosm of this case, that the way we deal with the instructions to the jurors and the arguments and the deliberation, it's completely antiquated, doesn't fit with how humans actually process information, right, and do decision making. It really needs to be revised, is unfortunately the reality. It works better in simpler cases too, I think, though. If you've got a simple assault or some kind of street crime, the instructions are simpler, the legal concepts are easier, and the case is going to be smaller and go faster. It works well in that scenario, but the more complicated the case becomes, the less well it works. So, all right. Well, so I was following a little bit. I don't know if people are following him on Twitter. Andrew Giuliani, who has been sitting in the case and giving Twitter updates and also little recaps. He said that during the one of the breaks yesterday, apparently the government had told the judge they were only going to need 4 hours, and the judge had said that well, if they went beyond that, they were going to need to make like childcare arrangements for jurors if they were going to go into the evening hours, which is another reason why you don't do this, because jurors are worried about their personal life. um, but evidently they took a break, a restroom break, and a letting people straighten out their logistics break, and a couple of reporters he overheard saying that they thought the argument had gone on too long for the government and that he had in fact lost the jury, and by one of their count it was 7 for acquittal and 5 going the other way. They're just observing, the jurors' responses to things. But this seems to me to be consistent with kind of from afar how I saw the evidence come in, right? That this is the kind of case where there could definitely be a hung jury and possibly an acquittal. Um, and probably the least likely outcome is a conviction. But I would caution people, you can, unless you're sitting there watching the jury, how they're taking in the evidence, it's extremely difficult to predict what they'll do. But what do you guys think? What's your overall impression of sort of what the outcome could possibly be here.
I've refused to predict what any jury will do.
Yeah, right.
I'm old enough of a trial lawyer to have learned that long ago and had
Right.
to
Exactly.
relearn it over and over and over again. Uh,
Right.
so
Right. So anyone who tells you that they know how it's going to come out is a fool or a liar. So there you go. But setting that aside, King, like some people have said, well, his New York jury for sure they're going to convict him. Doesn't feel like that to me.
uh, I can only give you my impression of the evidence based on posters on X, uh, and
Right.
I've read several. Uh, pretty, they're pretty much in agreement as to how the evidence came in and what it showed. And if I were a juror, I would acquit. Um, I, however, I don't think uh, you can say that as to all persons who heard the same evidence. Uh, Even
Right.
without any bias, you're going to get some tending to convict, others
Right.
tending to acquit, and it's going to be a heated dialogue in deliberations as to which side comes out on top.
Right. Well, let me ask you it this way. Do you think there's any possibility of an acquittal?
Uh, Going in, I thought there was uh, until we got to the instructions. Uh,
Right. And so people know the instructions always sound bad. Do we agree on that? Like when you're the lawyer, the defense lawyer, and you're sitting there listening to what the law is, it always sounds like it's so slanted in favor of the government.
that's true generally, but a clear set of instructions at least creates a bar that the
Right.
prosecution has to jump over,
Get over.
and
Right.
these instructions don't do that.
Right. Yeah. It was. That was my point. Is that it always sounds good for the government, but here I thought that was particularly so. Following it this morning. Is that what you're saying, King?
Exactly.
Yeah.
Yeah, I mean, I mean, criminal instructions are written to define a crime. And you've just
Right.
spent weeks hearing about evidence of a crime. So they always tend to be written into the evidence. Um, and, it is normally an uphill slog for the defense to make much headway in the language of the instructions. Most
Right.
principally because, you know, 95, maybe not that much, 90% of criminal jury instructions are standard from case to case. The only thing that really changes is whether certain instructions go in or don't go in based on the evidence.
Right.
And
Or how strong the
and
language
and the
is
language
one way or
and the
another.
language of the instructions defining the offense conduct. So in this
Right.
case, I mean, I just think the little bit that I've read about how the instructions ended up reading, I mean, Merchan is effectively instructing the jury to convict.
Right. It sounds an awful lot like that. It's a little bit hard to tell because we are getting it secondhand from people, many of whom are not lawyers, saying what the judge is saying. so, so there's that problem. But, and I'm just trying to caution people that it kind of always sounds that way when you're on the defense side. That the instructions are pretty damning. So you have to filter that out. Um,
Let me jump in. Where these
Go ahead.
jump off the rails, in my opinion, is that they give the jury a menu, a multiple choice menu of crimes to pick from, and they don't
Right.
require the jury to be unanimous on which ones they pick.
Right. This is the big issue in the case, and we're going to talk about that in detail
Even
as we go. Go
even
ahead.
short, even apart from that, nowhere in the instructions does the judge tell the jury these are. I'm listing you the essential elements of the crime that the government has the burden to prove beyond a reasonable doubt. Essential element 1, 2, 3, and 4. If if the government fails to prove beyond a reasonable doubt every one of those, you have to acquit. That's not there. There's no.
Well, it purports to be. This is what's interesting about it. But the judge has basically decided that something that maybe should be treated that way didn't have to be, right? Because he's telling them the government has to prove beyond a reasonable doubt the intent, whatever that is. That's really where the main problem is, right? And the false business record itself, blah blah blah. So, what really, King, what you're getting to is there's a part of the proof where there's a dispute between the two sides as to whether or not it's something that has to be proved beyond a reasonable doubt, and all 12 of them have to agree on it or not.
Uh, Yet, in addition to that, though, there are certain basic elements of the bookkeeping crime, such as
Hmm.
intent to defraud. He, he he doesn't treat that as an essential element. He doesn't define what that means. These instructions, and so
See, I find that hard to believe. How can that be? That's just baseline
it
criminal
it,
law.
it
Of
is.
course,
But
the intent to deceive has to be, or intent to
the
falsify is an element that they have to be
the
unanimous
the,
on. Of course, that's
the
how it is.
he says they have to be. This is what is charged, and you have to find beyond a reasonable doubt intent to defraud. But then he doesn't explain it or define it. He struck
Mhm.
the defense proposal as to what that sentence meant.
What intent to defraud
Yes,
means? Right. Okay. Well, in some places that is the way they do it. They say that everyone understands those words. That intent to defraud means intent to defraud, and everybody knows what that is. So that's something hopefully his lawyers preserve for
the the,
appeal. I've always
the,
thought that that's not
in
quite right,
in this
but
case
yeah.
it cannot be right because it uh, it leaves open to jury interpretation. The issue is who who. There's nowhere in the indictment does it say
I mean, who's being
who is being
defrauded?
defrauded
Right.
of what.
Right.
and
Right.
and
Which is why I think the better law, which is the law other places, is that is a term of art that lawyers use, that legislators use, right? And that the jury does have to be given some guidance about that. But I know of law in multiple states that goes exactly the other way. So that must be either the law in New York or that's what Marchand thinks the law is. That's a phrase that everyone is plain English and people understand what it means.
in the case of an ordinary theft by fraud case, for example, yes, it's clear the person who is giving up his money caused by
Right.
the fraud. It's obvious. It's on the face. But this is a statute and a set of facts that
Hmm.
it's not clear at all. And neither side argued this, by the way.
Well, that's what's going to be my next question for you. Do you think that Trump's lawyers preserve that for appeal?
They asked for the instruction, got denied
Mm,
it, but then they didn't argue. They
okay.
didn't argue
Right.
who's been defrauded here.
In the closing summation, you
Correct.
mean? Okay. All right. Well, and this is a problem for all lawyers on both sides of the case. So you want your instructions, you see the law a certain way, and you ask the judge to instruct that way. And if he doesn't or she doesn't and does something different, you have to conform your argument to the instructions of law that the jury is going to be given, even if you don't agree with them. So at that point, maybe his lawyers decided that's just a tangent. Let's just not go there. That's not the strength of our defense. But so people know, if they asked for the instruction and the judge would not give it to them, then that has preserved that issue for appeal.
Uh, the I would not if I'd been in their shoes. I think that's a key issue as to
Hmm.
an essential element that they could have gotten the jury's attention on because everybody in the company under the prosecution's theory, that is the Trump organization, allegedly knew what was going on, so they weren't defrauded.
Right.
The tax people were not defrauded because they got actually paid more taxes under the prosecution's
Right.
theory than the other one.
Because they plussed up the
Right, than
amount.
the other
Right.
would
Yeah.
was, and that leaves only the uh, Federal Election Commission, campaign commission, that might have been defrauded, but that's not for the New York state to enforce. Right.
All right, so let's turn to that issue, and then we're going to come back, King, to your issue about whether the jury had to be unanimous on things. Because as we talked about this morning, we both agree that's really the biggest legal issue in the case, um, in terms of what the appellate court might be interested in, right? So, but let's talk for a few minutes about this first question. So, it seemed to me that it was also an unusual, to my eyes as a mid-Atlantic lawyer, feature that the arguments went with the defense gave their summation first and then the government gave theirs. Every place that I've practiced, the government gives their closing argument, the defense gives their closing argument, and then the government is entitled to a rebuttal. But that's not what they did here. And doesn't seem like Trump's team objected to any of that. So that must be the procedure in New
It's
Uh,
York.
by
What do you
it's by
guys think?
statute. I saw a
yes,
statute.
Oh, it's by
Yeah, I saw a
statute.
statute published yesterday that actually lays out the process of the trial from start to finish, and it provides
Okay.
at the end that the defense shall give summation first, followed by the prosecution summation, followed by the judge's instruction, followed by the jury taking the case.
Okay.
so
All right, so that explains it then. It's New York procedure. Now, as a defense lawyer, I think that procedure is completely inconsistent with due process and liberty interests. And I always have thought the procedure here was also inconsistent with liberty interests because it has always struck me that if you were on trial for your liberty and in some instances your life, that probably due process would mean that you'd get to have the last word to the person who's making the decision about those things. But that historically has never been the way that we've done it. So, all right, so they're following the statutory procedure. But my question really for you guys is what do we think of following that procedure in a situation where the government has never made clear what the second offense was, the offense that was, as King was saying earlier, it made it a felony if you were intending to commit or cover up a second offense. If the defense has never been told squarely what the government's argument is as to what that second offense is, how in the world is that due process that you have to make your arguments first and don't have any rebuttal?
that that is you've put your finger on the essential due process and uh, Sixth Amendment violation because uh, you don't get to know for sure what horse the prosecution is riding until you've have nothing, no way to rebut it either by evidence
No
or
way to
argument.
address it. Right. Right. Exactly. To me, this is just entirely inappropriate and, as you say, arguably completely unconstitutional too. But I haven't seen anything indicating that Trump's lawyers have objected on that basis. They did try to get at the beginning, didn't they, what lawyers call a bill of particulars? Like they tried to get the judge to force the government to say, well, what is that second offense? And the judge wouldn't do it. Am I remembering that right?
Yes, yes, you are,
Right.
but I'm with you. I was surprised that they didn't object every time the government mentioned the second crime, the possible second crime, because they had Trump had a due process right to know ahead of time before trial what that was going to be.
Or at least as you went along, like at different points in the trial also, right? Like before certain evidence was put on, or as certainly before the arguments are made. So I mean maybe they clearly have preserved it by asking for it pre-trial, the issue sort of in a big picture. But I'm with you, I probably would have made objections, either written or oral, at every time that issue came up,
Yes,
right? To point out all the ways that you're now being prejudiced by this
yes.
problem.
What they got was a list. I think a list of 3 possible other crimes.
Right.
And
So you figure out what it is and defend against
cor-
all of it.
cor-
That's not how due
correct.
process works.
Well, let me make it even worse, based on some stuff that I heard yesterday from and read, which I think were from legally sophisticated individuals that were familiar with the proceedings that had taken place months ago. The government argued, and Merchant accepted, that the reason they didn't have to specify the predicate crime that was being covered up was analogizing to a 40 or 45-year-old New York State decision in a burglary case. Now, what's common
Right.
law burglary? Breaking and entering into the dwelling house of another with the intent to commit a felony therein. Okay,
Right.
that 50-year-old case says the jury did not need to be unanimous as to what the felony was, the purpose for going into the house, because burglary's
Right. That's the
malum
law
se.
here too.
Burglary's malum
Yeah.
se.
Right.
Any felonious
Malum and say, but wait. Malum and say is a crime that is. How would you define that, Ship?
a crime that is, I mean, it's not a crime simply because it's prohibited by statute. That's malum in
Right.
prohibitum. It's obviously of immoral or improper purpose or character, whatever the historical
To
definition.
break into someone else's
Right.
dwelling
You
place.
have no
Right.
legitimate reason to break into the dwelling the dwelling place of another at night. That's
Right.
the common law definition was it had to be at night. Now that's been modified, obviously. So that was the government's argument, is that, well, analogizing to that statute, there's no unanimity requirement for what the felony purpose of breaking in was, and that's the same here. It can, but then it gets even worse in that the government argued, and apparently I don't think it was resolved against them. I don't know how it played out in the arguments, that the underlying predicate crime doesn't even need to actually be a crime, because the statute says unlawful. And unlawful can be something that's just a civil, like an FEC violation that produces a civil penalty is still unlawful. That's the basis of the penalty. You violated the statute that carried a civil offense or a civil punishment. And the government argued, so not only do we not have to specify that it's a felonious crime, we don't even have to specify it's a crime at all, only that it is an unlawful purpose as opposed to a lawful purpose.
Right. And so folks know this case, this issue is a tremendously complicated legal problem. Just layers upon layers of complexity. So let's try and break it down a little bit. So let's first help folks understand the unanimity concept. Okay. So unanimity is unanimous, right? Same word, which means all of the jury has to agree. That's the baseline in American jurisprudence. To be convicted in a criminal case, generally, the jury has to 100% agree. Now, some places by statute, they've modified that, right? King, is Louisiana one of the states where they've done that? I seem to recall it might be.
Louisiana had a 10 out of 12 rule until it was reversed by the U.S. Supreme Court about 4 or 5 years ago in the
Right,
Ramos case.
right,
Louisiana
exactly.
and Oregon
So,
were the
right,
holdouts, that they did not
right.
require unanimous verdict by the jury. Louisiana, I know, was 10 out of 12, but the Supreme Court,
Oregon might have been Oregon
yeah,
9,
I
right?
think
So,
that's right.
yeah,
Supreme Court held both states' process was unconstitutional, violation of due process under the 14th Amendment, which incorporated not only the Fifth Amendment due process, but also Sixth Amendment right to a jury trial.
right. So folks know when I went to law school, which I'm the most recent law graduate here, and that was 25 plus years ago. When I went to law school, that was not the law. The law then had only said that unanimity of course was constitutional, but some
Leslie, I've lost you. Ship, can you hear?
Okay, I have my mic turned off. I can hear you, King, but she went electronic and then went away.
yeah.
Okay, now,
Can you hear me now?
yes.
Yes.
Yeah, I got the message that it was unconnected and then reconnecting. So let me say again. So when I was in law school 25 years ago, the law had only developed to the point that the Supreme Court said, of course, unanimity, everybody had to agree, all 12 or however many jurors you have. Everyone has to agree. That was clearly constitutional, but there were differing views and opinions as to whether you could have less than 100% of the jury agreeing on whether the person was guilty at all. And different states had different numbers. All of them were more than half, but some states had, three quarters. Louisiana, 10 out of 12. I can't, let's have 5/6. So, but eventually, but this is recent law, as King is saying. Eventually, the Supreme Court said no. It's really nothing less than 100% of the jury agrees is consistent with our ideas of due process. So now that's the law everywhere, state and federal, because it's constitutional law.
Let
Okay.
me add
So
that
then, go
what
ahead.
that means. The implication of that is that
Yep.
not only do they have to be unanimous as to guilt or innocence, but that requires them to be unanimous as to each of the essential elements of the crime charged.
Right, that's where I was going. So that then the arguments for lawyers became, well, what are those? For each, what then what do you have to be unanimous about? What do they have to have unanimity on? Guilt overall, yes, of course. But short of that, what parts do they have to all of them agree on? And so now there's all this law and litigation on what constitutes and what lawyers call essential element of the offense. And for some of them, it's easy, right? Assault is, the unwanted touching of another, right? Most That's a simplified version of it, but pretty much, there's not that many elements of assault, right? But for statutory offenses, which a lot of these are in this New York case, and for complex fraud type offenses, it's not always 100% clear what part of the case that the government has to prove is an essential element. So I don't know of any place, do you guys, that has ever said, and this would seem like craziness to me anyway, that the intent element is not an essential element. We're all agreed on that, right?
I always thought that was black letter law.
Yeah, me too. You didn't need a case to say so. That's just that everyone knows that's what the law is. Okay. Okay, they have to be all unanimous on everything. They have to be unanimous on guilt. They have to be unanimous on intent. But that brings us down to this issue that Ship's talking about. There are cases, I think everywhere that I practice, that say they have to be unanimous on the intent. But if the intent element has an object with intent to do XYZ, then if that intent object is specific, you have to have the intent to, let's say, commit rape, just to do an easy example. You have to have that intent. Well, if you have a different intent, then you're not guilty of this particular crime. You haven't, broken into the house with the intent to commit rape. Okay, but maybe you broke into the house with the intent to commit assault. And that was the beauty of burglary, was you to commit burglary, you had to break into the dwelling house of another to commit a felony, or with felonious intent, or intent to commit another felony. But under burglary rules, these are going back hundreds of years, the government didn't have to prove what other felony you had the intent to commit. It just had to be felonious conduct, right? So I'm not surprised, are you guys, that they were relying on that old precedent, those old ideas?
Uh, I'm not surprised that a prosecutor might think think
That was their
think of
theory, right?
doing that or having that theory,
That,
but it has
yeah.
serious due process issues that it raises, uh, particularly in this case with this statute. Let me explain that. The
Okay.
underlying first degree false entry or false bookkeeping entry crime says it's a crime to make a false entry in the books and records of an organization or an entity uh, with the intent to defraud and to either commit or cover up another crime. So if all you have is false entry with an intent to defraud, it's a misdemeanor, as to which the statute of limitations has run long ago in the Trump
Right.
case.
In Trump's case,
It
right.
becomes a felony where you tack on an additional intent element to commit another crime. So it's without the other crime, it's not a felony.
Right. So we all agree, and I think the judge and even the defense lawyers in Trump's case did too, that the government had to prove beyond a reasonable doubt to all 12 jurors that he, the president, had the intent to commit or cover up a second crime. So far, everyone.
You cut out again. Hello?
Yeah, I can hear you, but I can't hear her.
Oh, can you guys hear me now?
Now you're back.
Yes, I could.
How
Are you
about
still?
now? Can you hear me?
Yes.
Yes. Add this to my list of complaints about the management of this institution.
Let me pick up. Here you have it's the other crime that
All
makes
right.
it a
Can you hear me
felony.
now?
Yeah, can you hear us?
Yes, I can hear you. I can hear Ship.
I can hear you, King,
I
and I can
cannot
hear
hear
her.
anybody. If anybody can hear me, wave at me.
Leslie, I can hear you sometime, but not all the time.
Okay. Ship, can you hear me?
Yes.
Okay, but I can't hear you guys. Unacceptable. I may at this point decide to do this a different way, and I will announce that we're doing it on X and but we'll do a different platform. It's just unacceptable is the only word that's come into mind. So hopefully Ship can join back with us again. So we were talking about how because of that old law, which has been the law for a long time, that if an intent element has a second crime as the object of it, there's plenty of law that says the government doesn't have to um, necessarily say ahead of time what the second crime is. They do ultimately have to prove that that person had that intent. But this is different from proving that the person committed the second offense. They have to improve. They have to prove the person had the intent to commit that offense. They don't have to prove that the person carried it out to full completion. And then, as Ship was telling us, this statute also says the government doesn't have to prove beyond a reasonable doubt that it was even necessarily a felony, but only that it was unlawful conduct. Um, so the other side of the argument is that it's mostly a due process argument. King, would you agree with that? That okay, but it's unfair, which is not a legal principle really, but that it deprives you of your ability to properly defend yourself if the government doesn't have to say what that second offense is. And now we've doubled down on that. The judge has instructed the jury that the government also doesn't have to prove what the second offense was doesn't have to prove to the jury one offense that they all agree on, that it could be one of several different things, different second offenses that were the object of the intent, and that that is sufficient. So that's what the judge instructed the jury this morning. Professor Turley pointing out that government gave the jury three options, so four of them could pick one, and four of them could pick the second one, and four of them could pick the third one, and so clearly they're not unanimous then on that issue. And the question is that going to hold up under due process principles? So, Ship, I just sent you the second co-host invite too. So, King, what's your take on this, knowing that there is this background law?
Uh, it, I think it's a due process issue first and foremost, because without that second crime, uh, you don't have a crime. There's nothing to prosecute because it's not a crime. It's not a felony crime in New York to alter your books and records without the second crime, without the intent to commit a second crime. And in this case, it's not even a misdemeanor because the statute of limitations is run. So it's that second crime charge or as being part of the charge, the intent element is essential for the crime to exist. And
Right.
so I,
That's where I was before I got cut off, which is, do we all agree that the prosecution had to prove beyond a reasonable doubt, and all 12 jurors had to agree that there was an intent to commit a second offense? Not for the moment, let's not talk about what that second offense is, but that there had to be intent to commit a second offense or cover up a second offense.
yes. And I
Right.
think the jury was instructed to that. It's
Right.
just they got to do a multiple choice,
As to what
not
that second offense was. Right.
correct.
Right. Okay. So, but I just want people to understand. So, I think all lawyers and the Court of Appeals, if they ever get this case, are going to say, of course, the government had to prove beyond a reasonable doubt that there was intent to commit the second offense. The real legal question is, did the government have to prove beyond a reasonable doubt what that second offense was? I think everyone's going to agree on that too, or at least the unlawful conduct. And the real question is, do all 12 of them have to agree on what that second offense or unlawful conduct was? And so, what do you guys think of this?
That's one issue. Before you get there, could I
Yeah,
raise my
sure.
uh, uh, 2 cents on what's been in my craw since this case was filed?
Yeah,
The one of the listed possible second offenses is
yeah.
violation of New York election law section 17-152,
Okay.
which is a conspiracy to influence an election by unlawful means. So there you have another second offense as an essential part of that statute, because people agreeing or conspiring to win an election is not a crime.
Right.
That's what elections do. But what makes that under that statute in New York, what makes it a crime is to combine with others to do it unlawfully. And in my opinion, very strong opinion, uh, that statute has been superseded and preempted by the in federal elections by the Federal Campaign Act, which by its express terms, Section 30143, I think it is, says it it supersedes and preempts all state law on that
So,
subject.
all right. So, you guys, you can see just how really super complicated this is, right? Because now we're down to one of the three theories that the government wants to use as the object of the intent is a crime that may, in fact, under federalism principles, not be a crime at all, right? If it's preempted by federal law, then the state statute is not a criminal offense, nor would it be unlawful. And so then that would be something that the government couldn't possibly use as the object of the intent for this books and record keeping offense. It's astonishing to me how complicated this is on a statutory books and records argument. But this is what happens when you, as a legislature, you create these offenses that have these multiple intent elements or subparts. So, all right, so King, that's a good pickup, because if the Court of Appeals comes along later and says, well, they couldn't be given this buffet of choices of what the what the object of the intent crime was, and you gave them the buffet, and maybe we're okay with that, but one of the buffet items that you put on the buffet was not, you couldn't put on there because it's not an unlawful conduct, it's preempted by federal law. That would be a reversal then.
Yes, and if that was the thrust of the prosecution's case, it really brings into question whether the court has jurisdiction in the first place.
Right. Well, this is another layer of complication, and I want to get to that, but let's save that for a little bit later. So, Ship, what is your view as an old prosecutor? I mean, I was not surprised that the prosecutors went with this old burglary law that says we don't have to prove, one crime. It can be any criminal conduct or any unlawful conduct as the object of the intent.
Okay, so I've kind of held my tongue here, letting you
Yeah, go
guys
ahead.
kind of work through it. But right off the top, based on what the tactics and the strategies pursued by the prosecution, my first reaction was they don't care if this survives appeal. The surviving appeal is of no consequence to them. All they're interested in is stacking the deck in the best possible manner, factually and in terms of the legal instructions, to get the conviction. Getting the conviction is the only object here. Because,
Well, and maybe not even getting the conviction, but just putting him on trial.
well,
Right.
that too. They've now
Yeah.
aired all the evidence.
Right.
The whole sordid affair with Stormy Daniels has now been testified to in great detail, including a never before made allegation that maybe it was not consensual, whatever happened, if anything.
Right.
That's now out, comes out in courtroom testimony under oath. That the star of 250 pornographic films somehow, was rendered, unable to resist or remember, what happened, whatever. But here's the problem. The whole smorgasbord or buffet style election, if you don't define those crimes for the jury, how is the jury supposed to determine if those were actually crimes?
Right. And this is another layer of complication. This is why I keep saying it is astounding how complicated this is.
Yeah, you can
Because,
give them, just like you
right,
said, say the buffet is okay, and there's 4 buffet items. We'll talk about the one King mentioned just a second. And there's
right,
4 buffet items, and the judge says, you can choose among these 4, you don't have to be unanimous. Well, how's the jury supposed to know if the facts satisfy the
right,
elements of any of those crimes?
right.
Unless you define the crimes for them. My understanding is he didn't do it. And as for the statute King's pointing out, I think, King, it might be a different statute, but I think the definitional provisions for that statute make clear it only applies to state offices, not the office of the presidency. So it doesn't even apply to congressional or presidential or senatorial elections. It only applies to state elections. So if the government made that argument, but that's why they wanted to avoid having to define these offenses, and not defining the offenses led them to the position of, they don't even actually have to be crimes. They only have to be other unlawful activity, violation of some statute, whether criminal or otherwise.
Right.
Because
but
if any statutory violation, criminal or otherwise, can be the basis of the felony, then we don't have to define the crimes because crimes aren't required.
that's what the instructions sought by the prosecution say, and given by the judge. That's kind of how the instructions work. But and here's a big but here. In opening statement, the prosecution laid out in clear terms facts that fit the crime defined by Section 17-152, a conspiracy to unlawfully affect an election, and it was unlawful because they monkeyed with the books and records, and it was unlawful because they violated the Federal Campaign Act limitations on corporate donations to a campaign. So one, they argue and put on evidence that there was a Federal Campaign Act violation, and that made the manipulation of the books and records unlawful under New York law. If you go dig into the federal law on that, there is a criminal provision of the Federal Election Campaign Act that makes it a crime, a felony, to make an unlawful or participate in making an unlawful campaign contribution. And there's also a federal crime to willfully cover that up. It's Section 1519, an obstruction statute. So, in essence, the government in this case put on a Federal Campaign Act violation case and a federal obstruction of the Federal Election Commission by altering the books and records so they wouldn't find out. So this was a federal case that they put on, but then they've covered it up with these vague pick your buffet item type instructions.
Yeah, well, that was clear.
Right.
That
And
was
that,
that was clear from them wanting to focus on Pecker's non-prosecution agreement, the national requires non-prosecution agreement with the federal government, and Cohen's guilty plea to a federal campaign law violation. So that was obviously going at that sideways. That's what they wanted the jury to infer.
Right. Which, again, raises two issues for me. One is the just tremendous complexity here of trying to align this case with all of the sort of background existing legal principles that go with intent. Can you guys hear me now?
Yes.
Yes. Okay. It's just layer upon layer upon layer of legal issues, and this we haven't even talked about, King, your issue about does the state prosecutor's office have the ability to quote unquote prosecute these federal crimes? There's two sides to that argument too, right? You could take the position that, well, basically they're doing a federal election campaign crime prosecution under the guise of the state prosecution. They're not allowed to do that because they don't have jurisdiction to prosecute those crimes. Okay, but the other side of that argument, which the courts might accept, is that that is not what they're doing. That what they're doing is putting on proof of this second offense, which is the object of the intent, and that they don't have to have jurisdiction themselves to prosecute that second offense because that's not what they're doing. They're just saying that was the defendant's intent. Like they could have picked, violation of federal tax law, right? I don't know of any case that says that for an intent object element like that, the prosecution has to have jurisdiction to prosecute that other crime. Maybe this case will create that law, but it seems unseemly that the object that they're trying to prove, the object of the intent, is a federal violation. But I'm not aware of any law that says they're not allowed to do it that way. So the Court of Appeals and even the US Supreme Court might say that, yes, that's okay too. But when you step back, however, and you look at all of these things that by themselves are okay because the law says in one way, shape, or another you can do this, but when you layer them all on top of each other like this, what you end up with is, how is the defendant supposed to defend himself, right? When you don't know what it is that the object is, and they don't have to prove that by unanimity, and it could be something that the state doesn't, not only do they not have to prove, but they don't have to tell you, and then it doesn't even have to be a crime, it could only be unlawful. At a certain point it's so attenuated that you're being prosecuted for just doing something that the government doesn't like, is one way to look at it. But I will say that argument seldom works in the courts of appeals. They seldom conclude that that means that you were actually deprived of due process. They more likely just go through, as I've been doing, playing devil's advocate, saying, okay, but the law allows you to do that, doesn't it? And the fact that when you pile them all up on top of each other, it makes it really difficult, doesn't mean that it's unlawful or not a violation of due process.
Let me ask you this
So I'm
question.
concerned. Well, let me just say one last thing, which is I'm concerned that at the end of the day, the courts of appeals could easily say, if he were to get convicted, this is all fine. Go ahead.
Well, and this is just, it was, the question came up. This is sort of a tangential issue. The question came up, over the last couple of days of, will Merchan put Trump in custody immediately if he's convicted? Which
Right.
just to me is the
Yeah.
most ridiculous concept in the world. But I thought, well, what would happen if he did? And I know there are procedural barriers ordinarily, but I'm wondering if just to make the point, the very next day, could Trump's defense drop a habeas petition in the Southern District and say this prosecution was so blighted by constitutional errors that violate due process, he should not spend a day in jail until the process works itself out. Old-fashioned produce the body based upon a constitutional violation offense.
That would be very risky, right? The habeas law, as you know, basically the Congress has
I know.
ratcheted that back to, you can only do one habeas unless you've got new evidence that comes along later and a few other exceptions. If you used your one habeas card now and you needed it later, on the other hand, this is the kind of client where maybe you just don't worry about later,
Well, and I think,
right?
the statute provides for second or successive habeas petition. Just have to, you have to get permission to
Yes.
do it. And I don't think under the circumstances, the Southern
Yeah,
District or
you
the
might
Second
you might be
Circuit,
able to
yeah.
do that. That's true. Yeah. But it's another example of the process itself. Kind of, this is how it goes. And as a defense lawyer, I'm not surprised at this. But I often find that people on our side of the political spectrum, um, are surprised that this is how the criminal defense system works. But this is the system that we have. It's tremendously unfair in many, many, many ways. Um, I'm also not surprised that a state court judge is kind of really not dealing with the true level of complexity that we have here. What do you guys think of that?
I think that is not at all inconsistent with what I see in other parts of the country.
No, me neither. King, what's your thought on that?
I think uh, he is intentionally avoided the complexity. He's trying to make
Yeah.
this as simple uh, as he can of a state prosecution of a state crime that by its terms is not simple and implicates all sorts of constitutional and separation of powers issues.
And just what would normally, even setting those constitutional issues aside, what would normally be difficult, complex legal questions under the criminal law, and he's just like blowing by those as if, oh, this is just a easy little case. It's totally, totally not. Even if it weren't Donald Trump, this theory of prosecution is very complicated. But he also seems to me to be just absurdly biased and either doesn't care about that or he's entirely unaware of it because he's in denial because some of his rulings,
Well,
I mean, as a defense lawyer, you get used to and you get ruled against most of the time, but this looks a little off kilter to
yeah,
me.
I mean, I think King's right, and you're right that he has simplified the analysis
Yeah,
through his rulings and the jury instructions, so as to minimize, to the greatest extent possible, the potential for a hung jury. In other words,
right.
if you
Yeah.
narrow the path they have to walk down and exclude alternatives or side roads that they might take in their discussions, if you just kind of wave them off and make sure they understand they don't have to do that, it's expediting the verdict. And again, it goes back to he doesn't care what the verdict is. Neither the or the he, neither he nor the prosecutors care about the appellate consequences of these decisions. And this goes back to something that I said, uh, long ago, and kind of made fun of. And I don't think I made fun of it here yet, but I will now. It's like this case was never supposed to go to trial. Okay, this was the redheaded stepchild of the 4 cases that were filed. The first case supposed to go to trial was, the first case that was filed was the Florida documents case. And then when
Right.
they realized they might have a problem moving that case along rapidly, they ran to D.C. and filed the D.C. case. And then right after the D.C. case, the Atlanta case got filed, essentially piggybacking a lot of the theories and the facts of the D.C. case with cooperative work between the feds and the Atlanta district, or the Fulton County district attorney. Now I don't remember exactly when in the sequence Bragg filed his case, but it was late. It might have been the last of all of them because, well, I don't know. I can't remember what it was. But actually, I should.
No, I
I just
think
had it
his
up.
case was the first one filed, wasn't it?
I actually had it just a second ago. Here it is. Let me see. I have it on my screen. I was looking at the wording of the statute. Let's see when this is signed.
Because when the others came along, he was making all that noise about how he would defer to
Right,
them.
December 5th, 2017. So, oh no, those are the dates I'll check. So I don't. So what I have does not have a date on it. It's not signed. But This is the other one. It has a statement of fact.
Am I remembering that
Oh no!
wrong, King?
Oh no!
Wasn't
Here it
this
is.
the
Here's the
first
press
case
release. Yeah,
filed?
yeah. April 4th, 2023. And then the Florida documents case came along in June, and the DC case was August 1st,
August.
and the
Right.
Florida case was not too long after that. So this was the first one filed, but when the
Right.
others, and I mean I don't think Bragg could predict when Smith was going to file the 2 federal cases. Um, but I
Right.
don't think this case, given that New York trials tend to take years to get to court, except for this one, um, uh, I don't think anybody expected this case to actually see the inside of a courtroom, and certainly not to be first. And that's that's why I think they are the prosecution has struggled to present anything that you know experienced criminal litigators would describe as a coherent case, and
Coherent. Exactly the word that
and
comes
the
to
ju-
mind.
and
It's
the
not.
judges
It's
simply
completely
and the
incoherent.
judges simply helped them along at every juncture where he could.
Including this narrowing you were just talking about. I was going to jump in and say that. It's like all the simplification that he did, all of it went in the one direction, all of it favoring the government, not the defense, which is usual, but only kind of like way more so in this case than your typical criminal defense case.
It so much so that the instruction on the other crime, uh, there there's one part of it that's entirely circular.
Right. I was going to ask you about that because it's like the bookkeeping offense becomes the thing that is also covering up the bookkeeping offense, right?
Yes, it the other crime is a bookkeeping offense. So it
Right. Right. And that's how you committed the state election law violation, was by doing the bookkeeping offense. Well, it can't be both the intent and the object of the intent. That can't be. So the complexity here also, I think, plays into the issue that Ship alluded to, and that any lawyer that I've talked to who's not suffering from TDS is of the view that this case should not have been brought. That under normal circumstances, this is not a case that would be prosecuted because the theory of prosecution is so convoluted, arguably isn't right from start to finish, but that just in the exercise of prosecutorial discretion, this case would never be a case except for who this defendant is, which is, as a lawyer, this is one of the most offensive things that can be done under the law, is to prosecute someone because of who they are.
and it's not an insignificant fact that pretty much the same facts, the same theory of the case, if this stands, if Trump is convicted, New York could go after practically any candidate for federal office under this theory, because they're not bound by limitations that the FEC puts on these kinds of prosecutions. And you don't forget what happened when the feds tried to prosecute John Edwards.
John Edwards,
Uh,
right, which is why they didn't go for it in this
exactly.
case, I
Yeah.
think, don't you? Right. So, but I just want people talking law, not talking politics. I just want people to realize that, the legal issues presented in this case are are such that a court of appeals, taking them on individually, might say that what this judge has done in terms of instructions and what the prosecutor's theory is, they might say there's nothing wrong with it, even though when you step back and look at it, it clearly is wrong. Ship, did you want to comment on what you think we didn't get to you in terms of what do you think might actually happen here? I mean, my feeling is good odds for a hung jury, but from afar, that's what it
Well,
looks
yeah,
like.
I mean, there's a lot of thinking about that just in terms of sort of the political realities of New York City, and some of the things that I've heard mentioned that sort of weighed,
Right.
that that seemed meaningful and likely to me was, one, what are the chances that you've got at least one or more jurors, in Manhattan that have TDS, and anything that hurts Donald Trump in their view, they're willing to do.
Right.
And so I think the chances are pretty high that you have one or more jurors of that mindset. I mean, because it's
You're saying in which case you're not going to get an
yeah, they're
acquittal,
not
an
going to
outright
quit under
acquittal.
any
Right.
circumstances, because that'll help Donald Trump. So they won't lift
Right.
a finger to do anything that helps him. And I think the polling for just the presidential race, you can see the absolute stridency against him in many quarters of the Democrat Party. There's that it's
Right.
just beyond the pall for them that he could possibly win a second term. So I think, taking into consideration, now let's weigh that a couple other 80-20 for Biden in 20. So presumably, 1 out of 5 potential jurors in Manhattan were Trump voters. So
Right.
is
So that's 2, maybe 3 on this
correct.
jury. Right.
So if you just put raw politics into play, those 2 or 3 are going to be much more open to the idea that this is all a scam show trial. He's being railroaded just because he's running for president. So um, so that's a second, that's a second issue. The then another consideration was, okay, well, let's assume that you're one of the jurors that hangs the vote. one of the two lawyers, let's say the two, you're going to assume in the aftermath of the trial their identities are going to become known, and other jurors say, yeah, the two lawyers, blah blah blah, wouldn't vote to acquit because they were too legalistic on their consideration of the evidence. Well, those two lawyers got law practices in New York City, and how they are they thinking in the jury room, this is going to get thrown out on appeal, but if I vote to acquit, what is my partner's going to say back at the firm, or solo point, so those kinds of these considerations all enter into jurors' minds when they're considering what they're doing. And then I kind of just made a humorous comment on X yesterday where I just made a kind of an throw off post that said, you know, a hypothetical juror number one, you know, this guy might win the election in November, and then he's got control of the FBI and the IRS. Do we really want him to have our names and having voted to convict him? So, so does that thought cross anybody's mind in the juror room? There's lots of extraneous considerations. My experience, jurors always try to be fair, but they never limit themselves strictly to what they've heard inside the courtroom. And and
Right, that's my
and
experience too. They think they're being fair, even when they're not, and they don't set aside the stuff outside. Now, to a certain extent, we don't want them to, right? This is why we have juries. We want the community to bring its considered judgment to bear on these issues. So that's both the upside and a downside. Um, yeah. So, but this is just a case like no other, do you think, in terms of
It
what the
it
jury
it it,
could be
it
experiencing?
is. Uh, Let me say, I'm a great believer in the jury trial system, as because I think it's been my experience that jurors take their job seriously. They try to put aside biases. That's not always possible, but they do in their minds think, and they try to do the right thing, uh, with rare exceptions. So I would expect this jury, at least on the surface, to try to do that. Uh, but again, is it to what extent is it possible for them to abandon all prior preconceptions and biases? I don't think that is possible. But they're not doing
Right. Never
they
is.
generally
And in this
don't do it
case,
consciously.
right, exactly. That's my point. It's not usually conscious. They think they're doing the right thing, even though they are completely biased. They just don't see it,
So,
right? Or they persuade themselves that that's not true.
but there's an aspect that,
So,
of this of the closing arguments yesterday that to me is throws a wrench into the whole process. We
uh-huh.
heard, according to everybody's posts, my conclusion was you had defense followed by the prosecution, and as to what they were arguing, they were practically on different planets.
Right. The approaches to explaining and understanding the case were very different. Go ahead, King. Tell us
Yeah,
about that.
the defense went first, and their focus was on whether or not uh, the prosecution had proved that Trump knew about the payment that Cohen made to Stormy Daniels, one, whether or not Trump knew about uh, Cohen's intent to be reimbursed that by submitting uh, legal invoices to the Trump organization. Uh, Basically, the defense was, Cohen may have talked to Weiselberg about all that, but he didn't talk to Trump. When he says he talked to Trump, he was lying. And you can't
Right.
believe lying, the gloat, the, the greatest liar of all time, Cohen, on
Right.
this point. And the
He called him the human body, the human embodiment of reasonable
yes,
doubt. That is a great line. That made me
it
laugh.
really is. Uh, and they did not address things like, was this a campaign a campaign finance violation, or
Right.
was there a conspiracy to violate the campaign finance laws. They mentioned in passing it wasn't a tax crime, but didn't really go into the ins and outs of that. The focus was Trump's knowledge and intent. But then you go to the prosecution, and their whole pitch was this is a conspiracy. These
Right.
people met and conspired to pull off a fast one in terms of the campaign finance laws, and to cook the books to hide the fact they did that. And so those are things that the defense never talked about.
Right. And this is not at all uncommon, right? That the defense is singing one song and the prosecution singing another. Um, it also points out that all the things we've been talking about today, these are all legal issues, but those aren't necessarily the defenses that you argue to the jury to try to get the acquittal.
The I wonder, never having tried a case where the defense gets to go first or has to go first, followed by the prosecution, particularly where you don't know what the prosecution's theory of the case is until they finally tell us at the end of the trial. Uh, how do you think that approach of the defense, by not covering all the bases ahead of time before the prosecution comes back and tells a different story, how does that play?
I thought that Todd Blanche was smart in the way he went about that because he he basically said Cohen is a liar and you can't trust him or believe anything he says. And he's tied to all of their evidence. So it's not a case where they could say Cohen is a liar, but the government still has proof because they've got these other things over here and he didn't touch those. So when you're a little bit in the dark, like Blanche was about exactly what their theory is, I thought that was a smart move. Go to the evidence. Say this is an unreliable witness and it taints all of the evidence. And so it kind of doesn't matter what the government's theory is.
Yeah, that you guys have already mentioned, and I agree. This the order of the presentation of the arguments is particularly problematic in a case like this, where it's not like it's a murder case. You know what you're
Right.
defending against. You know the essential aspects of how the government has gone about proving your client's guilt, and you immediately go after them. And I think
It's not a moving target.
this is
Right.
reflected, and in this is reflected in the 7-hour government close. It's like, well, we're going to
Right.
go everywhere and talk about everything that the defense
Right.
didn't, and then we're going to drive home the fact that the defense didn't, which is a concession by them that they know how damaging that evidence is.
The,
Which is,
the
Right.
one thing the defense
King?
left alone, and which surprised me, was they knew from the opening statements that the government was pitching a conspiracy theory.
Right.
But central to that conspiracy was the empty chair, Weisselberg, who
Right.
was in all the meetings, had his hands all over how the books were done, gave the instructions. You took the instructions from Cohen and gave the instructions to the accounting department. Uh, he was not called by the government as a witness, and they really didn't have anything from him that tied him one way or the other to this
King,
alleged conspiracy.
King, can I just jump in just for a second? I need to jump off. I just had a message. I've got to make a couple of
Oh,
important phone calls. I will come
okay.
back in if you guys are still going, but I need to take off for a few minutes for now. All right.
Okay. I think we've been going for a while. I think we're going to wrap up
All
anyway,
right.
Ship. So good
All
luck
right.
with that.
Thanks.
Um, King, so yeah, so getting down to the end, I agree with you. It's like, well, the government wants to wander all over the map with all of this stuff, but what really difference does that make when, you know, you can't believe the one guy they brought in, and also they didn't bring in the other guy who maybe could have illuminated some of
Uh,
these things.
Not only
But
could he have illuminated him,
yeah,
but he is the literal empty chair. He is
right,
central to the whole scheme, according to the government's theory. And
right. But yet, where
where
is
is
he?
he?
Right, right. Yeah. Well, they made a strategic decision not to talk about that, the defense, clearly, don't you think?
Clearly, they did, but I didn't understand. Still don't understand it.
Right. Yeah. They and these are the choices you have to make when you're a defense lawyer, right? You can't it does not work with juries to defend on multiple theories. You might have multiple theories, but you can't use them all. This was often a struggle for clients to understand, because jurors think if you're saying, well, no, the cup was broken when you gave it to me, and you never gave it to me in the first place. And oh, by the way, I gave it back to you. Juries convict people who defend on multiple grounds like that. If you're going to defend on multiple theories, they have to all be consistent with one another too, and they can't be undercutting one another. And this is sometimes hard to put together as defense counsel. So it could be that they just decided, saying, "Well, where's Weisenberg?" That sounded too much like there is a problem here. Um, that it might have sounded somewhat like a concession that there is a conspiracy.
Uh,
So
you could say it in a way, argue it in a way
yeah,
that avoids that. I think in the case of Weiselberg, you,
right,
you've told the jury that Cohen cannot believe. You cannot rely on Cohen, and the prosecution says that Cohen conspired with Weiselberg. He might have, been a prosecution witness, but he's not. That can only mean one thing. That
yeah, but I'd be afraid that some jurors would think, okay, so the two of them were guilty, but your guy's not. I'm not sure I believe that. Right? You run that risk. So, but it's just a hard decision. You have to, and most defense lawyers, sometimes wrongly, think you got to pick your defense and stick with it. Right? So but they're not always right about that.
I mean, the jury's going to think that anyway. So you've got to put that in.
That's
You've got to
true.
put that absence of that key witness. You've got to
Right.
put that in the context of
I agree.
reasonable doubt.
Because the risk,
That is the reasonable
exactly.
doubt. They
Yeah,
called
you
a
may be right.
liar, and they did not call to testify the
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 truth
the
teller.
the
Right.
uh, the guy that the liar says he conspired with. So you've got a
Right.
liar saying he conspired, and there's two people, and they chose the liar to be their witness. So what's that mean?
Right.
I think you can make more out of that.
Yeah, you probably could have, but sometimes people just get focused on the defense they're raising, and they don't want what they consider to be distractions. And a different lawyer might very well say, as you're saying, it's not a distraction. It's sort of part and parcel of your argument already, right? So, well, so we'll see what happens. Fox has got, I don't know if I've ever seen this for a jury verdict. They have a timer up that minute by minute is saying how long the jury has been out. I don't think I've ever seen that before.
They
Wow.
maybe they should add a smokestack, like like
Like
yes.
when we need a new pope. Oh my. All right. So it's a little over 2 hours. And it's very difficult when you're a lawyer to say, is longer better? Is shorter better? So the shortest jury deliberations I ever had was 15 minutes. That was the first case I ever tried as a student, actually, in the clinic at Georgetown. Um, and we just had convinced them that the client was innocent. So, they went back, and you could hear them laughing in the jury room. Um, and so the guy who was with me in the gallery listening said, they're not convicting your client because they can't be back there yucking it up and thinking they're going to send someone to jail. So that was the shortest one I ever had, and the longest was 3 days. In case I tried in front of Judge Sullivan in 2018. So, it's hard to tell. In that case, it was not. That case, we got a partial verdict. With the worst counts, we got acquittals, and some of the minor ones, we got convicted. So it's very hard to tell from the length of the deliberations, other than a quick immediate verdict is usually, well, not usually, I've never seen a quick verdict that was a conviction. A quick verdict is almost always an acquittal.
Uh, that's true, and I have a tale. One of my first jury trials, I'll never forget. It was delightful uh, while the jury was deliberating because the judge, an older man, the judge in the state court trial, uh, his practice was as soon as the jury was sent off to deliberate, he would invite lawyers for both sides to come into his chambers, where he would then pull out a unopened bottle of old whiskey, fine old whiskey, and we would start drinking his whiskey and swapping lawyer tales. That was the most fun jury deliberation I ever sat through.
Oh my. Well, I found the jury deliberations part difficult. It's very stressful. The client is upset, the family is upset, everyone's on tenterhooks, and it's a hard thing to experience, actually. Um, and you get a note, and that is something that could happen here. The jury has questions, right? You get told or called by chambers, don't go too far from the courthouse, because at any moment the jury could say that they have a question that has to be answered, and then the judge has to confer with the lawyers. And so it's a very stressful time for the lawyers and the clients. One thing I found very distasteful, as a defense lawyer, was at the end of this trial, you have a client you think is not guilty, and you've tried this case. You think the prosecutors have played unfairly, because in my opinion they always do. And then at the end of the case, after the jury steps back to deliberate, the prosecutor turns to you and wants to shake your hand. And that has always infuriated me, and I've always refused to do it, because I just stand there thinking, are you fucking kidding me? I'm not going to shake your hand after all the shit that you have just done in this case. Like this is part of some old time, we're all members of the bar, and we're all ethical professional practitioners. No, those days are fucking long gone. So, and the last several trials I had where I refused to shake the prosecutor's hand, they were surprised. And I just thought, you know what? You need to step back and take a look at yourself if you don't understand why the defense lawyer doesn't want to shake your hand. So, but those are, tales from the bar. So, all right. So Fox's count says 2 hours and 20 minutes. No note, no verdict yet, and no notes. As Ship was saying, jurors try to do the right thing. They have 34 counts. With those number of counts, I would have expected several hours, just they're working their way through, electing a four-person and working their way through the counts and getting everybody a chance to have something to say. So I don't think 2 hours and 20 minutes is long at all at this point. King, what do you think?
I agree. They first they eat lunch, so that
Right.
takes up some time, and they may somebody may have the bright idea we need to at least go to supper time so we can get fed again.
Right. Give more free
That's right.
food. Right.
So they're going to take their time.
Yeah. Right. So we might get a verdict today. That certainly is possible, don't you think?
Yes, it's possible, but again, I don't expect it before supper.
Right. If it's a hung jury, then, or if they've split on some counts, then it could be several days, don't you think?
Yeah, there's no telling. It hung juries, you know, I've seen a jury hang up pretty quickly, and they tell the
Right.
judge, we're
Yeah.
hung up and we can't come to a verdict, and the judge will give them some instructions to go try again, and
Right.
sometimes that
They're always shocked when that
will,
happens. They send the note to the judge, "We're hung, we can't decide," and they come back into the courtroom expecting to be released, and instead the judge tells them, "You haven't been deliberating long enough. Go back and keep going." And the looks on their faces is always amusing because they think they're done, right? And that's not what the
yes.
judge thinks. So, all right, well, um, we if there is a hung jury and he does give them instructions, that is definitely something we'll probably want to talk about because there's different ways to do that, and some ways are more. Uh, I'm going to use the word charged. Actually the word that the lawyers use for what the judge tells them is called a charge. And it is a charged situation because depending on the language that the judge gives them, it there's arguments about how fair it is. uh, the charge usually tells them to, be sure that they are in fact considering other people's opinions. As a defense lawyer, it always has sounded to me a lot like, you know, that they should be trying to come to a decision, even if it means they have to give up some of what their own views are on it. And I think that's
Yeah.
entirely inappropriate.
It's
Um,
colloquially known as the dynamite charge. And
yeah, exactly. The dynamite charge.
so, if the judge, I don't know what the practice in New York about how close to the edge uh, that charge can be, but uh, we may find out. We'll see.
Right. Yeah. So, all right. Well, King, do you have any other thoughts that you want to
No,
touch
no,
on before we
I'm
go?
done. I think we
Okay.
covered
Well,
pretty much the waterfront here.
right. Yeah. So we will see what they do, and there will, of course, be more to talk about later, I'm sure. So thanks for joining. I'll send Ship a note of thanks, and we will talk to everyone later.
Bye, everybody.